Good morning. If it may please the court, my name is Kyle McClama. I'm
Would you
the
like
appellant.
to have any time for rebuttal, sir?
I would like to ask for 5 minutes rebuttal. Thank you. I'm representing myself here, so out of my element, but I'll do my best. So this is an appeal of the trial court's order granting the appellee's amended motion to dismiss my complaint with prejudice. The trial court did so on 6 grounds. Failure to follow the procedural requirements of Florida Rule of Civil Procedure 1.071. Failure to plead an injury to suffice.
Sorry, I'm going to interrupt you on that first.
So,
My understanding of how the Attorney General would, how you made your notice to the Attorney General was that you emailed the complaint without providing a separate freestanding notice. Is that, do I have that right?
partially. I did, within the body of the email that I sent, outline the issues, the constitutional issues
So your
in
position
question.
is your email was,
In a
the content
substantive,
of your email would satisfy the notice requirement of the rule.
in a substantive standpoint.
And in any event, you got the complaint to the Attorney General.
Correct. And the Attorney General in their amended motion to dismiss does not allege that they didn't receive the complaint, only the notice.
I don't want to use up all your time on that one, I just need to verify my understanding. Is your email on the record? The content of the email that you submitted?
It is. It's record. It's found at 258. Okay, so to continue, so the second ground that the court denied or granted the motion to dismiss was failure to plead an injury to suffice standing.
Can I ask you a question?
Yes, sir.
Did you ask for leave to amend?
I did,
Okay.
and I was
You
not.
basically said, because you never got a chance to amend, right?
That is correct.
The first complaint got dismissed with prejudice, no chance to try to fix it.
Correct, and I did ask the court for that.
Okay.
Yes.
And did the court give you any kind of definitive answer?
No, Your Honor.
Okay, they just said no, okay.
Correct. So the next issue was failing to allege a justiciable controversy, and therefore the trial court said it lacked jurisdiction over the complaint. The fourth issue was failing to file the complaint within the 4-year statute of limitations.
And
Let's talk about
Yeah, go ahead. Go ahead.
Ladies first.
Your opponent contends that, you were subject to this statute in 2006 when your conviction occurred, and that your complaint was filed in 2022. How do you confront directly that argument?
Well, on 2 grounds. So the first issue, or the first ground is that, let's see if I can find that. So there's an 11th Federal Circuit Court case, Doe v. Swearingen, that held that a law inflicting a continuing and accumulating harm on a plaintiff actively deprives that plaintiff of his asserted
So, in terms of what you actually pled, because that's what we're pretty much confined to, is the complaint, you do go through a pretty detailed explanation of how the 2021 amendments dramatically changed the requirements of the statute as compared to 1997, which was the version that I think I've got those years right. The 1997 to 2006 version of the statute was not materially amended the way that it was in the ensuing years, and particularly 2021, if I understood your argument correctly.
Yes, ma'am.
So is part of what your position here is that the 2021 amendments were such a sea change to the requirements, the registration requirements and the honorousness of them, that sort of breathed life into your claim as of 2021?
Well, getting it back to this case here, the Doe v. Swearingen court case held that the continuing violation doctrine applied, so that when the commissioner continues to apply these onerous registration requirements, there's a continuing violation, therefore the statute of limitations tolls from that time. But secondly, the law itself, section 943.0435, actually requires that in order for me to be subject to that statute or sex offender registration requirements, that I have to be relieved of my sanction before I become subject to it.
Yeah,
And I was
that's the
still under
question I have.
supervised release.
I don't mean to interrupt, you. That's the question I have, because if you look at the statute, it expressly states a conviction, whether it's federal or state. And it appears that if you have a federal conviction, which you did in 2006, you were to register with Florida simultaneously as you did with the federal.
When you look at the statute, Judge Sleet, it states that yes, it has the convictions outlined, but after that, it also states that you must have also been relieved of your sanction
Okay, so
that's been imposed on you. And I think there was a second DCA case that talked about a financial sanction. And of course, the law was changed to kind of omit that particular issue. But in terms of serving a sanction of supervised release or probation, that the law still states that unless I've been relieved of that, I'm not subject to 943.0435.
So you registered in 2021 with the state?
I registered pursuant to federal law. The federal law required me to register in the state, in the jurisdiction, correct.
Just very in order, but did you
That's
register
correct.
pursuant to the Florida statute?
But I think in terms of the statute of limitations and when that would toll, it should be effective of when that statute applies to me. And what I'm saying is it didn't apply
The
to
state's
me.
arguing that it ran in 2006. If you registered in the state in 2006, that might make sense and it might have teeth. If you didn't register with the state until 2021, maybe that's different. I don't know what you allege. I mean, you're sophisticated. We appreciate that. We treat pro se's just like anybody else. But we're at the stage where we're looking, we can only look at the four corners of the complaint. And as you know, the statute of limitations issue needs to be on the face of the complaint. Whether it's there, whether you violated it or not, we have to look at the complaint. So, did you allege, I mean, the federal courts, the precedent talks about a continuing violation doctrine. I understand that. Did you allege, I know that you at length alleged the egregious, I mean, the burdensome effects of this statute, but did you allege that your complaint, which is filed in 2021, is based on continuing obligations as this statute had been amended? Does that make sense?
It does. And I did not allege any statute of limitations as it pertained to my original complaint. So
I would imagine though, had you been given a chance to amend, given how the court ruled, you probably would have been able to address that.
yes, Your Honor. And what happened is when the commissioner filed their first motion to dismiss, in my reply, I then addressed the statute of limitations issue there. And it was, at that time, that's when the case came out in the federal circuit, the Doe v. Swearingen case about the continuing violation doctrine. I asked the court to take notice of that as well. So, but you're right. If given the opportunity to amend, I would definitely put that in there, both those issues, whether it be the continuing violation doctrine or the statute itself.
For the benefit of your opponent, because I'm going to ask her a similar question, and this goes back to what I was asking you at the beginning. I'm reading your complaint, and half of it is devoted to the injuries that you're claiming to suffer by virtue of the 2021 amendments to the statute. The complaint was filed in March of 2022. And you're sophisticated, but the rule on this is the statute of limitations, and this is really directed to your opponent. The statute of limitations is the defense has to appear on the face of the complaint. So if half of what you're traveling on here is ways that the statute affected you in 2021, I'm struggling with how the statute of limitations as a dispositive defense appears on the face of this complaint. You may not be able to answer that directly, but I don't want to sandbag your opponent when she gets out there, and that's where I'm coming from. This. I'm
not quite sure that I understand the gist of the issue.
And I'm not trying to confuse you.
No, I mean, the timing of the complaint was based on my relief from supervised release, a life term, which I got granted, and then a subsequent grant of relief from my duty to register under federal law.
So one way of looking at this is that you've been released from all of your federal sanctions.
Correct.
When you say life term, you're referring to the state or the feds?
No, the federal judge, William
I thought
Terrell,
Judge
William
Merriday-
William Hodges sentenced me to a life term of supervised release, but it was Judge
Oh, it's a
Merriday.
15-year term of report. But Hodges originally,
He originally sentenced me
life?
for life term, and Judge
Okay, so
Merriday.
was this reduction based on a federal statute that allows for you to have a hearing?
Well,
To do that?
I first had the early termination of supervised release, and when that was granted, I subsequently filed
Okay.
for a termination under federal law of my duty to register as a Tier 1 offender.
Okay.
And so, yes, you're right, as a Tier 1 offender under federal law, it's 15 years, but I was granted a reduction. There's a 5-year reduction for a clean record. And so Judge Merriday granted that motion as well.
Want to talk about venue?
Well, yes, Your Honor,
Because, you know, that was part of the trial court's ruling. They said it's found in the wrong county. It should have gone to Tallahassee because that's where the commissioner lives.
correct.
You know, and you've responded under the sword wielder doctrine. The blow was inflicted here. Irrespective of that, shouldn't the case have been transferred, not been dismissed if that's what the trial court truly felt?
That's what I argue in my brief, Your Honor, is that the case law supports that it shouldn't be a motion, or it shouldn't be a dismissal with prejudice.
Well, let's talk about the sword wielder doctrine.
Correct.
Walk us through that. Why should it be in Hillsborough County?
Well, I was going to go through the justiciable controversy issue. I do allege that an injury has been inflicted here. One to
Included here in
suffice.
Hillsborough, on you.
Correct. Yes, Your Honor.
Or wherever you live in Florida.
Right. And I do believe there's a case right now, it's still pending. It's Harper versus Commissioner Glass in the Florida Northern District. And it went to a 3-day trial. And there that plaintiff alleged that the 2018 amendments to the traveling registration requirements infringed on her fundamental, or her right to travel. And the trial court there denied the commissioner's motion to dismiss, stating that it was just a statute, nothing else, nothing more, nothing less, that infringed on that right. And that case proceeded to a 3-day trial, and it's still pending an outcome. Now, I allege at least one of those claims. I allege infringement on my travel, my fundamental rights to interstate travel. So I believe that at least that claim should survive a motion to dismiss. But getting to the venue, as long as the injury, which I believe has occurred, that the sword wielder doctrine would apply. So the venue would be correct here. It would be in Hillsborough County.
Guess we can go back to your agenda now. Apparently you're not-
Okay. In terms of the justiciable controversy, as it pertains to my fundamentally protected rights, I wanted to just briefly cite a case. Again, it's the Doe v. Swearingen case, and they put it this way. They state that the registry law requires the plaintiffs to make multiple in-person reports each year, even if nothing about their registration information changes. In addition to that requirement, each day the plaintiffs must try to determine whether an action they take, whether, for example, they wish to purchase a car, book a weekend trip, or create a new online account, requires making an in-person report. The complaint contends that these reports are time-consuming and burdensome, and contrary to the commissioner's suggestion, this injury is not caused by the plaintiff's initial designation as sex offenders, but by the commissioner's continuing threat of enforcement of the registration and re-registration requirements. The plaintiffs allege that the commissioner's ongoing threat of enforcement continues to violate their rights, and for this reason, any injury caused by the ongoing duty to register supports a cause of action against the registration provisions.
You're right at your 15 minutes. You can go into your 5, or how would you like to?
I'll,
You can complete your thought, but.
no, that's okay. I'll stand.
All right.
Thank you.
All right. Thank you. Wilcox. Good morning.
Good morning. May it please the court. I'm Caitlin Wilcox, Assistant Attorney General, on behalf of Mark Glass, Commissioner at the Florida Department of Law Enforcement.
Let's get right to your statute of limitations argument.
Yes.
How is the time bar apparent on the face of this complaint, half of which is devoted to what the 2021 amendments result in for this plaintiff?
So I think it's undisputed that the plaintiff was placed on the sex offender registry in 2006.
Obviously.
And his chief complaints are really four. There's the privacy element of his name being on the registry. So that statute of limitations, that would have expired in 2010. He complained about his reputation, the erroneous presumption. Those have already been declared as unconstitutional.
But a lot of his allegations were about certain restrictions that did not exist between 2006 and 2021.
I think the only argument was the 2018 amendment that changed the requirement to registry from 5 days to 3 days. However, the argument he made is that with that amendment, the term day was vague. However, prior to 2018, they had already had the 5-day requirement. So the term day had already been established. And once again, there's a plethora of case law where it is not unconstitutionally vague. It's not
But
unconstitutional.
wait, I'm sorry, just going back to the comparison, and he does a nice job of this.
He does.
Comparing it. One of his allegations is that his right to travel is being affected.
Yes.
The 1997 version of the statute didn't regulate travel under his allegations. And now, according to what he's alleged, in 2021, there's a 48-hour reporting requirement.
Mhm.
And he goes on to explain some of the more nuanced applications of this. That's all the 2021 amendments. And
I don't believe those are the 2021 amendments.
I'm reading out, I'm looking at his complaint, which is what we're supposed to be reviewing right now.
Yes.
And these are the allegations that he's made, and I'm asking you to tell me how we look at this and say, this is inclusively time barred on the face of the complaint. And that, I mean, I've got some more questions for you about injury and the standard of review on the dismissal and doing it with prejudice, but to me, and, you know, we've all been there, moving to dismiss a complaint that we think is clearly time barred, but it's a high bar.
Yes.
Where the complaint itself doesn't say, well, you know, in the period of the statute of limitation, outside the period, done. And then, because most plaintiffs plead in a way that put something within the limitations period, and this plaintiff has done that.
So while he cites the 2021, I think it's because that's the current law. However, the amendments happened in 2005 with the Just for Lunford Act. They happened in 2018 when they adjusted the data registry from 5 to 3.
Amendments are within the limitations period, you filed a complaint in March of 2022.
Yes, but the only complaint he has of the 2018 amendment is that it's unconstitutionally vague because of the term day. And the term day does precede 2018. And so that we've already had case law established that the statute's not unconstitutionally vague.
Let me get on this point, since I'm focused on reviewing the complaint and not necessarily tracing the history of all of these
Of
amendments.
course.
What do you think the standard of review on the dismissal?
I think it's de novo, but whether it's de novo or if it's, abuse of discretion, I think this court will reach the same conclusion that the lower court did correctly dismiss the complaint with prejudice.
You're not contending abuse of discretion, you agree that it's.
That's correct.
At the end of the day, what this is really all about is Mr. McClellan's complaint that this Florida statute infringes on his constitutional rights, and he's enumerated those.
Yes,
And under the 10th Amendment, we know that states have the right to promulgate legislation for the health, safety, welfare, and morals of citizens, right?
yes, sir.
And it just seems like his fix is in the legislature, not in the courts, in the bigger picture. There's some procedural problems here that we're dwelling on.
Yes,
But at the end of the day, the bigger picture is a legislative fix, isn't it?
I agree completely.
I mean, he's an exemplary candidate.
I
He
agree.
is probably, I'm no expert, probably no risk to reoffend based on everything I've read. He's done everything everybody's asked him to do. I mean, anyone that would read his case would feel bad for him.
Absolutely, and I think he
Bottom
would be a
line
great
is-
candidate to petition the legislature. However, the case law is very clear that conviction is the standard, it's not risk of harm. That's been issued in case law all the way to Supreme Court. Additionally, the ask that he's requested is for a circuit civil court to remove him from the sex offender registry. There's no justification for that. The avenue for him to be removed from this list is to petition the circuit criminal court after 25 years of being a successful candidate. And that's his avenue. That is what the law allows. That's what the clear, unambiguous statute allows. So while federal court has different standards, the state of Florida has a constitutional standard that it is conviction-based. It's not about his risk of harm.
Otherwise, there would be a creation of a very fuzzy line.
Absolutely.
We would have Mr. McClellan, who have an exemplary record. People that almost have an exemplary record. And something, you know, it would become very complicated to try to draw this line and protect the public.
Yes. Yes, and that's where it's not unconstitutional for Florida to require the registration based on the defendant's offense of conviction and without the individual assessment of whether the defendant puts at risk of offending again. And it's not unconstitutional for Florida to require registration for as long as he is in Florida.
Let me ask you a question. Is this record sufficiently developed for us to even look at the constitutionality of the statute as applied to Mr. McClellan?
So ultimately, it's on the appellate to preserve the record. It's a very thin record. There was not a
He didn't
court
get much of a
order.
chance since he was denied his leave to amend.
So under the rules, he had opportunities to file an amended complaint. We didn't file an answer. We didn't file a responsive pleading. We filed a motion to dismiss. So he had opportunities to file an amended complaint. He did not prior to our hearing.
He says that he asked the trial judge for leave to amend.
That was after the court had issued the order dismissing the case with prejudice, not prior.
So he did that in his motion for rehearing.
That's correct.
Did your motion ask for it to be dismissed with prejudice?
We did, and the reason is because it is what he's asking for to be removed from the registry by a circuit civil court. There's no remedy under Florida law for that, so there's no case in controversy. Additionally, he's been on the sex offender registry since 2006, so there is a statute of limitations.
So how would this play out if you filed in the 13th Judicial Circuit in a felony criminal circuit court?
He has not reached the 25-year mark. However, I believe once he reaches that 25-year mark and he continues to be, upstanding citizen, I think that he would very likely get it removed. But that's the remedy under the current law. He doesn't get a carve-out special exception for himself by filing a declaratory
Well, he
judgment.
also has the remedy of having it declared unconstitutional as applied to him, right?
Because he's been on the registry since 2006, I don't think the statute of limitations certainly bars him from saying, I should not be on this registry. He's been on the registry list since 2006. Certainly, as the state legislature makes amendments, he could challenge those individual amendments as they apply to him, but that's not what this case is. He did not apply to have a 2018 change that made the registration from 5 days to 3 days. He filed to have it declared unconstitutional as applies to him and have him removed from the registry entirely. And there is no law or case law or statute that supports that. And that's why dismissal with prejudice was the appropriate course of action. And if there are no more questions, we would just ask that this court affirm the lower court's order.
Thank you.
Thank you.
Mr. McClellan, you have 5 minutes, sir.
I guess I'd first like to address the issue of whether or not my dangerousness is relevant. Because the United States Supreme Court in Connecticut Department of Public Safety versus Doe in 2003 said that dangerousness may be considered a relevant factor in a substantive due process challenge. In that case, it was a seminal case, but that was a procedural due process issue. And they upheld the statute, I think, in that case, on procedural due process grounds. But one of the justices in the opinion stated, well, if it was a substantive due process challenge, a person's risk may be well considered in terms of declaring a statute unconstitutional. In terms of trying to rehash, but I filed the motion for rehearing. I didn't expect, it was basically in response to the trial court dismissing the complaint with prejudice, was my effort to try to amend the complaint once as a matter of procedural rule. And that was denied. And so even though I may have had opportunities throughout the proceedings as the commissioner filed their motion to dismiss and then subsequent amended motions to dismiss, I still feel like I did the correct thing under what was required of me in preserving that issue and a motion for rehearing, asking to be able to file that amended motion. And the court didn't grant that to me. In terms of the assertion that there is no avenue for me to be removed from the registry, as the judge pointed out, it can be declared unconstitutional. And there is a case, albeit it's in Alaska, but the Alaska Supreme Court held that their registration scheme infringed on the offender's privacy right in violation of substantive due process because law enforcement's aggressive notification and dissemination of one's conviction, along with their personal information, can lead to serious consequences such as harassment and physical attacks. In that case, what the Alaska Supreme Court did was they required, or they declared as applied to that particular plaintiff, and gave them an opportunity to go before a circuit court and assess the dangerousness, which I know is not, again, available to me at this point until I get 25 years down the road, which I'll be in my 80s at that point. So there is that that's the reason why I'm asking for the declaratory relief. Else I would, if there was an avenue, a legislative avenue for me to pursue, I would have done that in the, I guess, criminal circuit court. I don't know if I have any other issues that I can refute at this point.
We have a really good handle on this case. You've both done well.
Oh, thank you.
It's a tough case, giving us a lot to think about, but you still have time if you'd like to use it. You have 2 minutes, actually a minute and a half.
No, I'll go ahead and stop there. I appreciate your time. Thank you.
Thank you, Bob. Rest of the day. All right. The third case, Progressive Select Insurance Company versus